Hi, my name is Janice Switlo, and today I want to discuss in full the situation that's occurring in Wet'suwet'en Nation. First, I want to explain that I have been told directly the creation story and the history and laws of this area of the world directly by a matriarch. It required a lot of translation. It took a lot of time. But after that was done, I made a commitment. I made a promise to that matriarch. And that's why I'm here today, seeking to protect and explain and clarify what exactly is going on there. Now, first of all, a lot of people look at this injunction that BC court provided and the holding a breath as to whether that injunction is going to be enforced. Well, first of all, let's look at what that court said, because there's actually aspects of what was said that are beneficial. One, the court was clear to say, hey, I know there's Wet'suwet'en law, but it's not justiciable in my courtroom. And she's correct. She's saying, look, I can only deal with matters that are brought under Section 35, either by way of negotiation and an agreement, or where a court has issued an order pursuant to litigation commenced under Section 35. Well, the Section 35 doctrine, without me spending a lot of time going into that, you can search through my YouTube video episodes, and you'll see I've devoted a few to discussing that. That's a domestic doctrine. So the court is saying, I have no ability to adjudicate and decide any matters of Wet'suwet'en law. The same way you wouldn't expect that court to be able to decide matters of law in some other part of the world, like Italy or Spain or Russia. She wouldn't be able to tell Putin what to do as president of his country. So there's a plus there. There's recognition that this law exists, and therefore there is a nation, continuing nation with continuing laws. Now, the other advantage is that there has been no agreement signed. There's been no land claim agreement signed that's done under Section 35, and there has been no order of the court issued under Section 35 litigation either. Yes, there were representations made in the Delgamuukw case. Now, these representations are problematic because you have hereditary chiefs and lawyers saying these people aren't a nation, they're under Section 35. Well, the people haven't agreed to that. The lawyers do not have that ability to make those representations for the nationals of the nation. Where a hereditary chief is making that statement, either in those court proceedings or as recently seen in media, where, for instance, I think it's Johnny Hawk that recently put up a YouTube video catching a hereditary chief speaking of himself as merely a Canadian and a British Columbian, and feeling that the court is very protective. He was not speaking of his own laws. Now, where you have a person who carries a hereditary name, they are bound by their own laws. Any statement that says, we're not a nation, we're under someone else, can only be made by that person in their individual personal capacity. Why? Because that's absolutely contrary to their law. Their law, their requirements and responsibilities as a hereditary chief is to protect their land, to protect their people, their nation. By saying, I agree, we're governed by Section 35, which is a domestic doctrine whose foundation is the doctrine of discovery. Now, I know no one wants to hear this who's been in this position and been involved in spending millions of dollars on lawyers to bring these matters forward on the basis of Section 35 and being told that they're saying the same thing. They're not. And I've also devoted an episode to explaining the distinctions between actual title that a nation holds and the quote-unquote Section 35 Aboriginal right of Aboriginal title. They are not the same things. I'm not going to repeat that here. So to be clear, you have a lot of people talking about this situation, but nobody's getting it truly right except for a person right there on the site. he has said and been quoted in media, look, I'm here under Wet'suwet'en law. He's made that clear. He did not say, I'm here under Section 35. He did not quote Delgamuukw case. He did not do any of that. He said, look, this is who I am. I'm of this nation. I'm here, and this is the basis upon which I'm here. Now, here's the point. It's trite that the law of a land applies where that land is. Now, remember that Her Majesty has not obtained permissions of any sort to be exercised on Wet'suwet'en land. And as I said, the Wet'suwet'en have not actually abandoned who they are and what they have and what their responsibilities are. Now, this is not meant as a slight to the hereditary chiefs, but it is not a simple matter of donning a button blanket. And I remind that as the result of the fact of murder of many hereditary chiefs, of names having to be hung up, of the fact of surviving a genocide that interfered with their governance in a big way, there's a lot of work still to be done in Indigenous nations on the West Coast and the Central West area, which, by the way, in that area, I'm known as Mother Grizzly Bear. So there are people cleaning house, setting their houses up, making sure the names are carried by the right people. But ever since I put on the formal record that, hereditary chiefs exist, these are their authorities. These are exercises of law and governance under their nations. Ever since that, it's been kind of popular to try to become a hereditary chief, because then, you have some power to be spoken to, and ideally, from some of these people's perspective, they can make some money off that. They'll have to get their signature. Well, that's contrary to Indigenous law as well. But the point is that there are some people carrying hereditary names that others allege they stole, simply for purposes of putting themselves into a position of power. So why am I bringing this up? Because there's a lot of due diligence also in terms of who's a hereditary chief. And I remind and emphasize that hereditary chief is bound to speak in accordance with and to act in accordance with their Indigenous law. And they cannot, under their law, abandon their lands. They cannot give it over and hand it over. And whether you like to hear it or not, Section 35 is a removal doctrine. And it's critical not to be seen to be agreeing that you come under that jurisdiction. And in fact, as said, a hereditary chief just cannot agree with that. So anyone in that capacity, the world has to understand they're speaking as individuals at that point, not as authorities under Wet'suwet'en law. The people who are actually speaking for Wet'suwet'en are nationals on that site where this injunction may or may not be enforced and implemented. So I want to explain how this has gotten much more complicated. Another lawyer brought to my attention, and publicly brought to people's attention, that there are Indian graveyards there, that Coastal GasLink has apparently bulldozed, trying to destroy, I have to conclude, the evidence of an Indian graveyard. Why is that so important? Why would such evidence prove so problematic? That is because every single Indian graveyard, that's the term that was used at the time this decision was made, every single Indian graveyard is a reserve. The federal government did not want to incur the expense of identifying all the Indian graveyards through having to survey them all at once. And furthermore, were concerned about the desecration of those Indian graveyards, worried people were going to dig them up to find trinkets and skulls and such. So the commitment was that as the need arose, those Indian graveyard would be surveyed, and its boundaries would be clearly made clear. Now, as has been shared, there are these Indian graveyards where these people are. And Coastal GasLink is trying to move in and do things there and obviously have already trespassed on these reserves. Now let's be clear, the province and companies cannot expropriate reserves. Only the federal government can deal with that, and there's problems proceeding under Section 35 of the Indian Act, precisely because the question is whether that is actually constitutionally valid, that section of the Indian Act. I don't want to get into all that because that's a whole other subject. So instead, Canada, the federal government, has tried to, whenever there's a need, for instance, BC defines a need for a piece of land that's on a reserve, the federal government has tried to broker a deal so that it would proceed under Section 38 of the Indian Act, which is a situation requiring a vote of the people. And then an interest can be granted. So we have a situation where there's actually, if these facts are correct, now remember, I'm not up there, I don't know exactly where these graveyards are. The whole point of the matter is they need to be determined. There's evidence, they exist. The next step is the federal government must, this is not an option, must find those, delineate them, survey them, make clear where they are. If this pipeline, wherever it's going through, needs to cross one of those, then we have a situation of Canada deciding either to use the Section 35 expropriation terms, and that's inviting a whole challenge, I would suggest, it's certainly by me, or proceeding on the basis of Section 38, which would require, in order to happen, would require the people to agree and allow that to happen. And in terms of allowing that, they may have terms, for example, of how to deal with the remains, how to move them, things like that. I'm not suggesting that they would actually agree. The point is they have a right to consent. And as I said, the province can't just go in there, and certainly the company just can't go in there. So I have some messages, some clear messages. There are people who are trying to support the Wet'suwet'en that are there and trying to protect them. They do not realize that, for instance, Stuart, you're referencing Section 35 in the Delgamuukw case in the recent press conference that was held at the Union of BC Indian Chiefs. You're painting a target on their backs of everyone who's up there because you're saying this is a domestic matter. And while you're trying to appeal to the world to say, look at this situation, every time someone like BC Civil Liberties says, oh, this is a charter issue, the charter doesn't apply to Indigenous nationals. Indigenous nationals are dealt with in a part of the Constitution of Canada outside of the charter. Every single land claim, self-government agreement, all these things always require them to agree that the charter will apply. The charter does not apply there. Well, I appreciate the effort to point out the human rights issues. Stick to that. Don't at the same time, while appealing to the world, call this a domestic matter, and that's exactly what's done when the charter is referenced. So the messages then, these people, I want to say to you, please stop. Please stop characterizing this situation in a manner that really helps Canadian governments. Please don't give more to Premier of BC to say, hey, this is, butt out, world. This is our matter. You have no business here. I'm here to say a few things specific to parties to this. Premier John Horgan, this is not just a domestic matter. This is indeed an international matter, and your very own court has recognized that in that injunction. Has recognized there is Wet'suwet'en law. If there's Wet'suwet'en law, there's a Wet'suwet'en nation. And I'm not talking about all of that having been put under Section 35, because again, as your own court has said, there is no order and there is no agreement, and therefore there is no jurisdiction of the court. What does that mean? Things that are not justiciable in domestic courts, that makes them international matters, and that's exactly what this is. To the RCMP, you took two oaths. One is allegiance to the Crown, allegiance to the Queen, and the other is to uphold the law. Now, while that court, BC court, said, I can't deal with these with certain law issues, the court is bound by the law. Now, without getting into challenging the veracity of and the ultra vires or not of the Indian Act provision, the fact is, these are reserves up there. There's Indian graveyards up there. Now, you cannot enforce an injunction on a party that's trespassing on reserve. In fact, your obligation is to protect that party from those trespassers. So the obligations actually reverse. And in terms of the responsibility, that's upholding the law. In terms of responsibility to the Queen, she's merely asserting authority. She has not been granted permissions by treaty. This is important to consider in the exercise of your offices. The Prime Minister, Department of Justice lawyers, further to my commitment to the matriarch of that area, one of the matriarchs of the area. If no one else is able to put this clearly to you, I do so now. Your obligation is to protect those reserves, those Indian graveyards. Your Department of Justice lawyers will tell you, I was one, will tell you those Indian graveyards are reserves. You must now find out where the boundaries of those are, find out where they are, survey them, make it clear where they are before anything further can proceed. To organizations and, the other do-gooders, as I said, please do not reference charter, do not reference Section 35, do not make this a domestic matter. Coastal GasLink and the holders of that entity, and ultimately the shareholders of those entities. Consider this: no treaties, no permissions to the Crown. How has the domestic court had to handle that? By creating this domestic doctrine which says, what's her source of sovereignty? She just asserts it. Well, in international law, that's called an occupation. That's an act of war. Now, she's got a problem. Her Majesty cannot do that because there are treaties in other parts of what she calls her Dominion of Canada. And she is bound by the duty of fairness to engage in proper treaty making before she can exercise these authorities. So your shareholders need to appreciate that investment in anywhere there is risky. You're not getting what you need to get in terms of certainty. And furthermore, if you've paid money to chiefs and councils who have passed a band council resolution and then entered into agreement with you, your lawyers didn't do their due diligence. They didn't check what's the limit of the authorities and jurisdiction of a band council. You have to look at the Indian Act for that because it's an Indian Act created body. It's a federal body under domestic law, and it has limits of jurisdiction. Now, to remind, you can't obtain reserve land, and that's what those Indian graveyards are. You can't obtain it by getting a BCR. You need to have the people agree to it. And, hereditary chiefs, some of you are in a difficult spot. I've spoken to many hereditary chiefs, and they've had to rely on lawyers, and they've, these are people who have been through a lot, and many of them are very old. And many have asked me for help and assistance. And when I've met with them first, and it's become clear how, they've accepted what they've been told because, of course, they are not educated. But when you talk to them about their law, they know their law. What I'm trying to convey to you with the utmost of respect is that what you've been told about what Section 35 in Delgamutte is completely contrary to your responsibilities as hereditary chiefs under your law. So, what to do next? Well, the injunction can be countered by providing affidavit evidence of the Indian graveyards. If someone needs my affidavit, ask. As I said, those graveyards need to be identified and properly surveyed before anything further can happen, so that we know what the situation on the ground is. And CGL, you can't just do it. You might have a permit from British Columbia government, but they have no legal ability to issue a permit pertaining to reserves. That's within the federal domain only, and that's only with respect to use of that land. There's various ways that can be approached. So, to be clear again, this is an international matter. This is quite, and without trying to be inflammatory about it, act of war. This is Her Majesty's government's acting contrary to her duties, her duty of fairness, because keep in mind, in BC, there's actually 2 areas where there's treaties. So parts of BC have already made treaties. And I'm not talking about the land claim capitulations. I'm not talking about final land claim agreements. I'm talking about actual treaties. You've got Treaty 8 and you've got the Douglas treaties. And consistently, until such time as this Section 35 doctrine was put in place, the elders who are ancestors who I have met and have heard and have reviewed what's been said in the past have always said, you need to do a treaty with us. They thought they were getting that. But as I explained in my document, Trick or Treaty, that was released in 1997, that's not what was offered. It was Pierre Trudeau's plan put in place with the assistance of his pal that he put on the Supreme Court of Canada. And as I said, there's episodes that I've recorded pertaining to all those details. So let's be clear. This is a serious situation, made even more problematic because people are talking about it and they're mischaracterizing what's going on. My prayers for the safety of the Wet'suwet'en nationals who are protecting their nation. Remember, at Gustafson Lake, the the green light order was issued, and that's an order to shoot to kill on site. And as RCMP confided in me afterwards, notwithstanding their oath of secrecy, they approached me to tell me, we received that order, and yes, we had to follow through with it, and we all did shoot. But, funny, they said, how no one actually hit their target. So without even communicating with each other, not one RCMP was prepared to kill one of the people at Gustafson Lake. Why? Because they individually swear their oath. So again, they as individuals need to consider, is this a lawful law that I'm being asked to enforce? Puts these people in a difficult position. And as I said, many of them came to me after my book, Gustafson Lake Under Siege, was released to fill me in on the inside of what was taking place. So let's hope we're not back in that situation. And let's hope that people will respect and not try to speak for. And as I said, I'm here speaking for because I made that commitment to matriarch. That binds me to speak up when others are not able to do so. Thank you for your time.